There have been many changes in the justice system in West Virginia in recent years, but how's that worked out? I'll talk with West Virginia Supreme Court Justice Thomas McHugh right now on The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
The longest-serving member of the West Virginia Supreme Court is Justice Thomas McHugh. In a sense, he's the institutional memory of the West Virginia justice system. Justice McHugh, thank you for coming up.
I enjoy being with you, Dan.
There have been a lot of changes since you first started practicing law and first went on the Supreme Court. How has it changed?
Well, really the revolution occurred in, I'll call it that, 1974, when the voters of the state passed what was known as the Judicial Reorganization Amendment, which brought all the courts together under the leadership of the West Virginia Supreme Court. No longer did you have JPs or Justices of the Peace. You had circuit courts. Magistrate courts, and then you had a level of circuit courts, and eventually the West Virginia Supreme Court of Appeals. And within the West Virginia Supreme Court of Appeals was set up an administrative branch, basically to administer the court system. And so from that centralized focus, the court system now is essentially run from Charleston, and which is a very good because it's standardized.
Was the organization of the court system significantly different prior to the Reorganization Act? I know we had Justice of the Peace courts, and we changed that to magistrate courts, but how was it organized previously?
Well, every court, every county had a JP, or Justice of the Peace, and each of the circuit courts were separated. A lot of the funds came for these various, and you had some specialized courts like common pleas in Kanawha County. Cabell County had specialized courts, but the money for those courts came from the county government. And you had juvenile courts and things of that nature. But under the Judicial Reorganization Amendment, all the money for the funding of the courts comes from the legislature.
You would not have had a uniform product, a uniform administration of justice with the courts fragmented like that.
You're exactly right. But critically on that is the education component. As many people know, formally under the old system, probation officers were often just errand people for the circuit judges, and they really weren't trained. Probation officers today are very professional. Most have graduate degrees, and they're encouraged to do that. So today you have a really professional group of probation officers. All the education for probation officers, for example, for magistrates, for circuit judges, for Supreme Court justices, and all the other parts of the judicial system are controlled, as I indicated, from Charleston.
Education. You're judges. You're supposed to know everything.
But you have to keep current with all the laws throughout the United States. And you really have to educate your probation officers in terms of current thinkings and things of that nature.
Well, and at your lower level courts, the magistrate courts, magistrates are not lawyers.
Correct.
They're not specifically trained to be judges prior to being elected.
Correct.
They are common people.
Well, and the courses are designed to give them some fundamentals in law, and they're very good at that. Take tests, and of course the director of the magistrate court stays on top of that. But they have two classes a year, and in the meantime, the irony is, We passed the Judicial Organization Amendment to get away from specialized courts, but now we've gone back to them to some degree because we have family courts. And when you created the family courts, you have another level that you have to deal with, and also another educational component.
Separate judges, family
And
court
separate judges. And as I indicated to you earlier, these were all countywide. The county supported them. There was some state component for the circuit judges, but it was not really great. And now it's all centralized, and that's a good term in terms of trying to keep a judicial system responsive to the needs of the citizens. In many states which do not have that, a system such as we have, it's really still fragmented.
Well, in West Virginia, you have some assurance by having an integrated judicial system that if you have a matter in Kanawha County or Ohio County or Cabell County or Monongalia County or Jefferson County, that the process is going to be pretty much the same.
Correct.
And ideally, the result would be the same. But
well, the procedure will be the same. You never can, the results may not be because you have different judges sitting in those positions, but that's the purpose of an appeal. So when it finally reaches the Supreme Court of Appeals, you hope you get that consistency. And when the Supreme Court makes a decision, it goes back out, then people, well, you hope, will follow the decision of the court.
Well, over the last few years, there was much criticism of the state Supreme Court because it was said, just kind of poo-pooed some cases, tossed them off, didn't listen to them, didn't allow appeals, and by golly, everybody was entitled to an appeal. There have been some changes made to that.
Well, there has been, and a lot of that was concerns we had. We thought perhaps we should have more direction when we refuse an appeal, for example. So under the leadership of then Chief Justice Davis, we studied some systems around the state, around the country, Roy Perry being the clerk of the court, being instrumental in it. So now, regardless of what happens, whether you win or lose, obviously I'm going to use that phrase because most people relate to that, you're going to get a decision and you're going to get an explanation for it. And of course, a lot of people were clamoring for an intermediate court of appeals. From the circuit court to the Supreme Court, they wanted a court in between. And from our perspective, we thought, well, that just added an unnecessarily bureaucratic level of maybe another $15 million. And so in order to try to alleviate that concern, we changed our rules of appellate procedure to ensure every litigant that comes to the West Virginia Supreme Court of Appeals, that they will receive an opinion, a decision.
Is it significantly different what actually happens, though, at the court? Previously, if, as a lawyer, I would bring a case down to appeal, and I would file brief and maybe make oral argument on it. The court accepted my appeal or did not.
Correct.
For your own reasons.
Correct.
In the old days, or before we changed this, you just didn't tell me why.
That's exactly right.
Now you do tell me.
And now you know why.
You're not really doing anything any differently, I guess, except writing it down?
The opinion, it's a lot longer. Obviously, there's an opinion there. So you know in an opinion that may be 2, 3, 4, 5, 6, 7 pages long exactly why the court refused your appeal. And before you had nothing other than to say it refused.
Yeah. One of the concerns I have heard voiced about the Intermediate Court of Appeals, proposal for Intermediate Court of Appeals, is A, as you mentioned, the cost to the justice system of having that court, but also wouldn't that increase the cost to the litigants significantly because you would appeal your case first to the Intermediate Court of Appeals, and if you weren't satisfied with the outcome of that, and one side wouldn't be, they would appeal it to the state Supreme Court.
The irony of that is, you're right, if it's good for one, it's going to be good for the other. So you have either a defendant appealing or a plaintiff appealing, you're going to get it. And there's some misconception that all courts allow oral argument, which is not accurate. No court, appellate court in the country at the highest level ever allows everyone to orally argue. I mean, you're dealing with thousands of cases, and so you couldn't possibly hear oral argument. An intermediate appellate court, West Virginia Supreme Court of Appeals, no one could do that. And so I think the issue sometimes, they lost focus on what the issue was. And we've tried to redirect that back. And so today we have the memorandum decisions or regular opinions or whatever the case may be. But there's a lot more work internally doing that because you have a group of people working very hard to see to it that these opinions are out, and you have the members of the court reviewing all this and getting the opinions out.
Well, there's a big difference between knowing what you should do with a case and justifying what you should do with it when you have to write it down.
Absolutely.
In the old college math text, there used to be the line after some horrible mathematical calculation, they would say the proof is left to the student,
Right.
and now you have to write the proof out
That's
to
correct.
tell people why. But that's not an unfair thing, and people are probably more comfortable
Right.
that they're being dealt with fairly.
I think so, and we've received very good reviews on that. I think most people are happy. Some people you're never going to satisfy. We just have to understand that. We accept that. But I think sometimes people lose perspective on things. And you know, there's always a perception of things about the West Virginia Supreme Court. And it takes years to overcome that. That they don't hear all these appeals, or they're not paying attention to them, and things of that nature. Well, I can go out, or Chief Justice Ketchum can go out, or Justice Davis, or Justice Workman, or Justice Benjamin explaining that's just actually not true. We can only say so much. And people may believe it or may choose to disbelieve it.
Well, one of the reasons I'm delighted to have you here today, and we've had other members of the court up to do shows with us also, is because I think there's a perception that there are these old men and women in black robes back behind this big black curtain, and there is a big black curtain.
Maroon
Curtain, and that you're just monolithic blocks of granite or something back
Right.
there. You don't have feelings, you aren't people, and we'd like them to see that, yeah, you're really back there, you're really people, and that you're concerned. But you are, in fact, people, 5 members of the court with very distinct personalities. We're talking about the West Virginia Supreme Court. My guest is Justice Thomas McHugh. I'm Dan Ringer, and this is The Law Works. And sometimes these are big personalities. And you're trial lawyers, most of you, as you come to the court. You're used to being the center of attention, center stage, arguing. How in the world do 5 people work together like that?
Well, it's interesting about the framers of the Constitution of creating a system of government that we have. And that's the one branch in which all 5 are equal. Now, you have a Chief Justice who's the administrative head of the courts, but in terms of the voting, that's 1 vote. And I'll just use our own group as an example. And I was there before, as you may know, and then I retired and came back. So I had 10 years out of there. And so I've come back, and I thoroughly enjoy the group that we have currently. Chief Justice Ketchum reads, thinks, works all the time. Not unusual for him to text me at 5 a.m. in the morning about a thought that he has. And Justice Davis, I've known from when I was there before, and she's an extremely hard worker, very intelligent. Her opinions are very masterful. And of course, Justice Workman I'd worked with when I was a circuit judge. She happened to be one of my clerks, law clerks.
And she, in fact, has served much as you did. She served
did.
a period, was out in private practice,
Right.
and then went back to the court.
Incredibly perceptive. I like to say you don't pull the wool over Justice Workman's eyes. And then Justice Benjamin is very easy to work with. And so he's an easygoing person from that perspective. And so he has his own views and very strong views on his own issues, but so I don't mean to infer that he doesn't. But when we go into conference, each of us have our own views, and we have to try to convince the other to accept our view or not. And so I always tend to laugh about lawyers. They don't understand if they have a case, they have to try to get the majority. But oftentimes they really have to get one member of that court that really understands what their issue is. And that one member then has to carry their water, so to speak, back into conference to try to convince 2 other members that that position is correct.
So I have to convince you to be my lawyer when you go back into conference.
Exactly right. And people don't understand that. The judges become advocates. Now, realistically, with the group we currently have, we're working, we talk with each other all the time. We don't just go into a conference room and vote. We go into each other's offices and say, what do you think about that? And have you looked at this? Have you not looked at that? And so as a result, a lot of times we go into conference now, we know what the vote's going to be because we've talked about it. But there's no rancor. If you lose the vote, you don't sulk, you don't pout. You go ahead and write a decision, dissenting if that's what you desire to do, or concurring if, I like the result, but I don't like the way you got there. But I have never heard an argument, strong argument, personal argument in the chambers since I returned to the court.
When did you return to the court?
At the end of 1997. Justice Davis had come on, and then I left in 1998 and practiced for 10 years. And then when Justice Albright became ill, the members of the court asked me to come back. Then Chief Justice Maynard, and then Chief Justice Benjamin, and then I was appointed by Governor Manchin in 2008, I guess it was.
How many years in total have you served on the Supreme Court?
Oh, probably neighbor 24.
And you started in 1980.
Yeah, 24, yeah, that's correct. Yeah, and then I had, I'm including circuit court time too.
Yes.
See, I was a circuit judge for such a long period of time, so you take that period and add it to the 17, 18 years, and you add another 4 years on it. It adds up.
So you practiced law.
Yeah.
You served as a circuit court judge.
Correct.
And you served as a Supreme Court justice.
Correct. And then went back to practice and back to Supreme Court.
That's
and I learned a lot between that 10-year period.
And that's extremely valuable experience. When you're practicing, and I've appeared in front of the court several times,
right.
and you're always wondering, what are they thinking? Sometimes you're wondering, what are they going to do to me?
Right.
Because you get some interesting questions sometimes.
Right.
But knowing that the people on that panel, on the court, have had experience doing just what I've done. They've seen the good, the bad, and the ugly of it. That always instilled some sense of confidence in me that I had a good chance of being understood by at least one of you.
Correct.
And if I can get that one to be my lawyer, I guess I'm in better shape.
You got it. And today, all 5 members of that court, when they go on that bench, they know exactly what that case is about. As I indicated to you, in many cases we've discussed it. And so the judges pretty much know what that is. And so we'll let the other members of the court, we know how it's going to flow. And if one other member of the court started asking questions that, yeah, that's what we would have asked. We don't just step in to do that. The lawyers have to understand that before the members of the court go out, they are fully prepared to hear that case. And they're fully prepared to make a decision in the case. And they're fully prepared to write a decision in the case. So I would hope that the public would understand that confidence level, or have confidence in us.
And the court evolved over the years, and you were talking a few moments ago about oral arguments. I saw that evolution. At one time, if you went down and had your case accepted, you would automatically go down and make an oral argument.
Right.
And over the years, that was diminished. And you kind of saw that coming because upon more than one occasion, I have had the Chief Justice, maybe you, I don't recall.
Well, it could have been.
You stand up and they look at you and says, "Do you have anything to add that's not in your brief?"
And that's time to shut up.
I got that message. Unless I really, really had something that I either forgot or didn't know to put in the brief and learned about it. But because that's what happened. You spend a considerable amount of time preparing the brief to put everything in it because you want it all in one place. So oral argument really isn't necessary in a case like that.
Well, it really anymore it is. And if you notice recently, and that's what's with our rule changes, if someone drives from Charlestown or from Martinsburg, you want to be heard when you come to Charleston. If you notice, that doesn't occur as fast anymore. I don't want to use a phrase that the trigger's being pulled fast. You're being given a chance to really explain it because oral argument does have some significance to it. And so the lawyers are being given more time for that. And they can be assured that they're not going to be stopped short of what they really wanted to say.
You've watched the evolution of the court over the last 35 years in the practice of law and being on the court, but you've also had an opportunity viewing from the bench in the other direction at the practice of law.
Correct.
Do you have any thoughts on how the practice of law has changed during your time?
Well, there are a lot of things that do bother me about it. I'd like to mention 2 things. Number one, you mentioned at the Supreme Court, and I want to go back to that. The brief writing is much worse than it used to be.
Worse.
I think that's because of the days of text messaging. Everyone wants to be brief, and sometimes those briefs are written in a manner that seems to be more in the nature of a text than a brief. And so I've seen a fall off in the quality of the briefs to the West Virginia Supreme Court. And that does bother me. As a matter of fact, before I came here, I was talking to one of my clerks who had been with me before, and I asked her about that, and she says she sees that difference. And Justice Ketchum and I have talked a lot about that. And I don't know all the reasons for that. Sometimes it looks as if the lawyer dictated the night before. Justice Ketchum will point out a case in which a lawyer filed a brief and didn't cite any cases. So that bothers me. The second component is do we have a profession or do we have a business? Today, lawyers have, many of the officers are very opulent. very, very nice and should be, but that's overhead. Someone has to pay for it. And so you wonder, are we getting ourselves into the same posture as a corporation? They are essentially are anyway, but are we then really any different from a hardware store? And that bothers me if we continue this trend. There's as you know, as a practicing lawyer, there's incredible competitive demands today. The advertising has created that to a great degree. The United States Supreme Court allows that, so people do it to try to get business, and I understand those things. But look at any day of the week on the television, the ads are filled, the television sets are filled with ads for lawyers. And you wonder how far that's going to go. It can not elevate the standards, certainly, but it certainly can lower the standards. Who gets there first?
Do you feel that, you were talking about the quality of writing, has legal education deteriorated somehow?
I've talked to people at the law school about that at times, and I wonder about that. I probably don't have enough definitive knowledge of exactly what the education process is there. When I was at law school many years ago, as you pointed out, the law professors were practicing lawyers. So if you took a course in property law, for example, that individual has been to the property, to the courthouse, and knows exactly what it is to search a title and understands it. Fortunately, at WVU, we're fortunate having Professor John Fisher there in property, so I shouldn't have picked that particular one out because he's one of the best. But I'll use that as an example of the teachers, the professors were trained in that particular area, and they conveyed it. I tend to think at times it's become a little bit more, not by everybody, but by some a little bit more academic and not as much pragmatic. And I
Theoretical.
You got it. And there is a debate among law schools, I understand that. Some schools have gone to that practical aspect of it. I don't know if it's how much it's going to expand, but I know they're starting to look at things like that. And I do think that we have to get back to some type of a more practical application of law. Law is really practical. We can think in the academic sense a lot and dwell on those kinds of things, but it really fundamentally is practical.
I'm really concerned about the diminution of legal writing. Words have meanings, and sentences are constructed in particular ways to say particular things. And if you're using shortcuts or writing casually, you just don't convey the same information. In legal writing, you always know when you're done because whatever you're writing starts to sing to you. It goes from one phrase to the next.
Right.
You've got counterpoint, you've got harmony. It sounds silly to say that perhaps, but it really does. And then when you give it to someone who can read,
Correct.
they get the music of it and they understand it better.
Correct.
So, well, it's not something, brief writing, for example, to the Supreme Court, is not something you do overnight.
Correct. It's you have to think your product through, your table of contents, the structure of the brief itself, thinking I've got to convince the reader of that brief that my position is the correct position. You don't have to say the same thing 4 or 5 different ways, which oftentimes happens. Someone thinks, well, the length of the brief is the better the brief. That's not necessarily true. If I'm reading a 30-page brief, for example, and I see 10 pages of it, and I get really the heart of it, but I start seeing on the 11th page or the 12th page a repetition of what I saw from the same thing, I'm just not going to read any more of it.
We've only got about a minute left, and I just cannot pass up the opportunity to ask you this. You're the longest-serving member of the Supreme Court. If West Virginia's court system is a hellhole, you must have dug some of that hole yourself.
Right.
Is there something wrong? Is our system fair?
Well, it is. And again, I mentioned to you earlier about this intermediate appellate court or intermediate court of appeals, what do you want to call it? That's absolute bunk. And it just takes a long time to get perception. And a lot of this is driven not from within West Virginia, outside West Virginia. A lot of these titles, judicial hellhole, they're not driven by West Virginians. They're driven by non-West Virginians.
I've never met a West Virginia lawyer or judge that would put that label on our justice system.
You've got it.
Justice Thomas McHugh, thank you very much, sir, for being with us.
Enjoyed being with you.
Thank you also for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. On the LawWorks website at thelawworks.org, you'll find a listing of recent The LawWorks programs, additional information about this show's topic, and video of this and recent shows. You can also find the LawWorks programs on YouTube and iTunes. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us email at thelawworks@comcast.net or visit us on Facebook.
The LawWorks is produced in cooperation with the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The LawWorks is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
From West Virginia Public Broadcasting.